Hello, welcome to our webinar, a part of our thought leadership programme for education, and we're very pleased that you can join us today. I'm Abigail Trencher and I'm head of the education sector group here at Birketts, and I'm a partner in the employment team, and I'm joined today by...
Hi, I'm Sonya O'Reilly. I'm a partner in our employment team as well, and I specialise in education and working with clients just like you.
And today we're going to be looking at a range of topics, looking at legislative developments in a range of legal disciplines. So we're going to kick off with employment, and Sonya and our colleague Charlotte Sloan will be taking you through employment developments and looking at some issues that are on the horizon. We'll then be joined by our student issues team, led by our partner Sara, who will be taking you through interesting patterns and developments in the area of student issues. And then we'll be joined by our colleague Robbie Watson, who's in our tax and trust team, and Robbie will taking you through issues that are pertinent in respect of tax, notably the potential for VAT on school fees and what that means in practice. We will then move to Amanda Timcke, a senior associate in our commercial property team, who will speak on who will speak on estates management at difficult times, and Emma Chiaramello, a senior associate in our construction team, will discuss the Building Safety Act.
Okay, so just how the format will run, as you hear, there's a number of people that are going to be speaking to you over the course of today's webinar, which we really hope you'll enjoy and find really useful, whether you're in the independent sector or indeed in the maintained school sector, further education, higher education. We hope that you find something of interest to you. One thing that we expect you'll have is a number of burning questions, perhaps, that you've either come to the session today with or that you think of during the course of our various speakers. Please do feel free to pop those into the chat. How we're going to deal with that, given the number of speakers, is that we will then respond to your question that you put in the chat by email. So please leave us your email address and we'll be very happy to respond to those questions. And indeed, if you don't put it in the chat and you'd rather email us separately, again, please email either Abby or myself. You can find our details on the joining instructions or indeed through the Birketts website, and we'd be delighted to answer your query.
Thank you. And as we've mentioned, this is part of a series of education thought leadership events that will be running throughout the year. So if you'd like to subscribe to hear more about our other events and podcasts, and to also receive our legal updates on the range of legal disciplines, then please press our subscribe button. The link will be available to you, and you can certainly select which legal areas you'd like to hear more on and those that you wouldn't. So without further ado, I'll now move to the employment part of today's webinar, taken by Sonya and Charlotte. Thank you.
And I'm going to take you through some really important developments that took place in 2023, and then looking forward to 2024 and beyond as well. And I'm joined by my colleague, Charlotte, who's going to be taking you through some of the employment aspects as well over the course of our time with you. So what are we going to look at then? I'm going to take you through, first of all, some of the changes that are afoot in terms of family-friendly measures. So I'm going to talk you through those. Then I'm going to look at some flexible working changes as well. And some issues around equality and diversity, which of course no HR or employment law update would be complete without some thoughts about equality and diversity. Charlotte's going to talk to you about holiday pay, because again, I think that's one of those areas which is never out of the headlines really when it comes to employment law issues. And then Charlotte's also going to talk to you about where we see some union activity in the education sector at the moment, and just some thoughts about some issues and some challenges that may be on the unions' minds, and therefore correlating into what you end up having to deal with. And then I'm going to come back and talk you through really some sort of horizon scanning about the political influences in mind at the moment, and particularly thinking forward to a general election and what that might mean, and what it might mean if we have a different government in due course. Okay, so without further ado, let's have a look at some family-friendly legislation and some points and changes just to be aware of here. Now, I'm not going to take you through in slavish detail these various aspects. They may well be things that you're already quite familiar with. They've been on the agenda in one form or another for quite some time, really, with the government having been talking about bringing in line some carers leave, some protection from redundancy for people on pregnancy or family leave, and indeed neonatal care leave for quite some time. But some of these are now expected to come into force. So the Carers Leave Act 2023 is expected to come into force on the 6th of April this year. Now, this is going to provide 1 week's full unpaid leave in any 12-month period for somebody who has particular caring responsibilities. Now, those long-term care responsibilities are really for somebody who has a physical or a mental illness, injury, disability, or indeed an issue relating to old age that somebody is required to care for somebody for, and that care is likely to be for more than 3 months. This right is going to be a day one right for your employees. So it is something that's coming into force. Now, it's 1 week of unpaid leave. It will remain to be seen how readily this is taken up, but it's certainly something to be alive to and aware of. Then we look at the Protection from Redundancy, Pregnancy and Family Leave Act. Again, expected to come in on the 6th of April. It's really an extension of the existing protection that there is for people who are on maternity leave. The protection currently is for those who are on maternity leave, where there might be a redundancy situation that takes place whilst they're on leave. And what's historically happened is that the person who is on maternity leave has a feeling that they might be overlooked for any roles or suitable alternatives or alternative roles during that mat leave period. So there has always been, for some years, protection for somebody during their maternity leave to be sort of given enhanced protections, really, and an enhanced right to be offered work that is suitable for them where there's an alternative in a redundancy situation. The change here is that that is going to be a right that is extended during pregnancy and beyond pregnancy for a period of time. And in fact, that protection during and after pregnancy and family leave is for 18 months after the expected week of childbirth. So that's something to be aware of in any redundancy situation to make sure you're not falling foul of anything there. We have the Neonatal Care Leave and Pay Act 2023. This one isn't expected to come into force this year. It's still not yet finalised as a piece of legislation, but we are expecting it next April. So it's just one to be aware of. And this is for parents of a child who is receiving neonatal care after birth for up to 12 weeks additional leave. Now, this is a day one right again, and the intention is that it would be leave paid at the statutory rate of pay if somebody has 26 weeks or more service. Now, this is really designed to try to assist parents who would otherwise be using up other forms of family leave in order to be able to be in hospital with their child, their baby who is undergoing neonatal care. This will give the ability for somebody not to be using up all of their other family leave options whilst that child is still in hospital. But as I say, not yet in force, coming potentially next year. And then finally, when it comes to family-friendly changes and legislation, the other one just to be aware of, it was laid before Parliament on the 11th of January this year, is the paternity leave amendment regulations. This is to provide for paternity leave of up to 2 weeks in total, but the change here is that it can be separated out into 2 separate blocks of 1 week each that can be taken any time during the first year after birth or adoption, rather than the first 8 weeks after birth or adoption, which is the current situation. There are some minimum notice requirements in place for this particular leave. So an individual would need to be notifying their employer of their intention to take this leave. And this is due to come into force on the 8th of March. So this is imminent. The other final piece of flexible working protection that I just wanted to draw to your attention is the Employment Relations Flexible Working Act 2023. This really is strengthening the entitlements for people when they're requesting to work flexibly. And this is all in line with the government's agenda, really, to try to assist in making the workplace a flexible place for people so that they can work in a way that suits them best. Now, the current regime that I'm sure you're all familiar with, which has been in place now for a number of years, is for somebody to be able to bring one request for flexible working a year. The change here is for that to be 2 requests a year. There are some other changes as well, and that is particularly that the obligation on the individual employee to really set out what the impact of their proposed change working pattern would be on the employer has gone. So it's not now going to be an obligation on the individual to really explain the impact. It's really more for the employer to work that one out for themselves. And the timeframes for requesting and dealing with a flexible working request has changed as well. So whereas in the current regime, an employer has 3 months to be able to respond to any flexible working request, that's being reduced to 2 months, or longer if both parties can agree an extension. We're still not entirely sure whether this is going to be a day one right, but we do think that coming into force, the flexible working amendment regulations coming into force on the 6th of April will create that right. Okay. Now, thinking about equality and diversity, there's one particular piece of legislation that I wanted to talk about, and it is the Worker Protection Amendment of Equality Act 2010, Act 2023. This is a piece of legislation that had been batted about between the House of Lords and the House of Commons for some time, actually, and it's due to come in from the 26th of October this year. Now, what we've currently got in the realms of harassment legislation under the Equality Act is that there is the ability for an employer to try to defend itself effectively against an allegation of harassment by saying that it's not vicariously liable for that harassment because it's taken all the reasonable steps that it could do to prevent that harassment occurring. And that is effectively a defence that an employer can currently try to put forward. What this legislation is doing is actually almost front-loading the protection for an individual in relation to sexual harassment only. So this will make it a duty on the employer to take reasonable steps to prevent sexual harassment of their employees occurring during the course of employment. So it's a positive obligation to be taking steps to prevent harassment on grounds of sex in the workplace. Now, when this was going through Parliament, there was discussions at the House of Lords level where the original legislation was drafted to be that an employer would have to take all reasonable steps. Now, that's an even heavier obligation. That has not found its way into the final legislation, so it is just to take reasonable steps. But what this legislation means is that if, as the employer, you don't take these reasonable steps in advance and try to create a safe working environment in the first place, then an individual can claim a 25% uplift to any compensation that they're awarded under the Equality Act in a claim of sexual harassment. There is a new code of practice that's been prepared as well, which actually has some really useful guidance in there about what an employer should be doing. But really, these steps must at a minimum include having good policies in place about what is expected of people from an equality and diversity perspective. it's also critically about the training that is put in place. Because if you haven't got good training in place to make sure all your employees, and certainly all of the people with management responsibility, understand how to nip any issues in the bud, how to address any concerns that might be brought up about any harassment, or indeed a culture in the workplace that might be inappropriate, then you will fail in being able to show that you've taken reasonable steps to prevent harassment. So training is really key, and it's really important that that training is kept up to date and is refreshed and alive, and not just a once and done kind of situation. That's something that we do help our clients with in schools and education establishments, and indeed across the board, to make sure that that training is really alive. So we're very happy to talk to you about that if that's of interest. I'm going to pass over to Charlotte, who's going to take you through some holiday pay changes.
Thanks, Sonya, and hello, everybody. I'm Charlotte, and I'm going to be talking to you about holiday and the latest on the ongoing saga of holiday and holiday pay. It's finally, however, good news for the education sector. So I've been talking about case law in relation to the working time regulations, specifically on holiday, probably for the last 15 years. I didn't think we'd still be talking about case law on holiday in 2024, but this is exactly where we are. Part of the reason for this is because the working time regulations, which emanate from the Working Time European Directive, don't deal with a number of issues which arise practically in relation to holiday. And of course, the working time regulations themselves date back to 1998, and the arrangements in the workplace have changed dramatically since then. One of the issues in particular the working time regulations don't address is in relation to part-year workers, and in particular for the education sector, term time only workers. The working time regulations don't deal with how you calculate holiday pay for those part-year workers. In practice, what a lot of schools and other education establishments have done is to apply a common sense approach and prorate holiday pay using a percentage of 12.07% to work out how much holiday a part-year worker accrues. And this made perfect sense and was applied across the board. That was, of course, until 2022, when we had the Supreme Court's decision of the long-running case of Harper Trust. Now, in that case, it was decided that because the working time regulations don't allow holiday to be prorated for part-year workers, including term time only workers, were entitled to 5.6 weeks holiday. Now, this caused absolute chaos in the education sector. At its extreme, it would mean that an employee who was working part-year 1 week a year was entitled to 5.6 weeks holiday. But in any event, it meant that the holiday entitlement was quite generous for part-year workers compared to full-year workers. Now, lots of you, no doubt, would have made changes to comply with the decision in Harper Trust. And there were lots of schools, colleges that we were talking to at the time who made those changes to make sure they were legally compliant. But in January 2023, took a little while, but finally we heard from the government that this potentially was going to be changed. So obviously this decision was costing them money. For state schools in particular, they were having to pay that cost of having to pay up additional holiday pay for part-year workers. And perhaps unsurprisingly, albeit they took some time, they announced that there will be a consultation to look to change the law. Now that happened, as I say, in January 2023, and it was closed in March. And then we heard nothing. So another period of silence until in May, we got another announcement of another consultation in relation to some fairly minor changes to holiday as part of the so-called Brexit bonfire, looking at removing certain parts of European law which are implemented in the UK. Then we had nothing. And no doubt many of you were wondering what was happening. We certainly had lots of schools in contact asking that question. Finally, in November 2023, the day before I was due to present on this topic at a conference, we suddenly got, in a flurry of activity from the government, the outcome of those 2 consultations and draft regulations with the proposed amendments to the working time regulations. Now that came into effect in 1st January this year. And as you will all know, the implications of those new regulations is that you can now prorate holiday for part-year workers. Coming into effect, whilst the regulations are in effect as of the 1st of January, the law doesn't change until the 1st of April 2024. So from the 1st of April 2024, you can prorate holiday for part-year workers. And the way the government have done this is they've set out a distinction between part-year workers and irregular workers as to how you do the calculation. But essentially, it's going back to what we were doing previously by applying the 12.07 percentage figure to work out the holiday entitlement. And we've got the calculation here on the screen. So what this means for you, there may be a period of time under which the Harper decision still applies. So up until the 1st of April, the law in relation to holiday entitlement for part-year workers is still in accordance with the Harper Trust decision. And many of you, like I say, may have changed the holiday clauses in the contracts to comply with Harper Trust. And if you have done that, or if you changed what you did in practice, even if you didn't change any contractual wording, potentially you're going to have to go through a consultation if you want to revert back to what you were doing previously and paying holiday in a prorated way for part-year workers. There are various options in that regard. So I think if you are looking at what you want to do going forward, certainly get some legal advice to try to make the process as easy as possible, because as you will all know, going through a collective consultation to change something which is perhaps not as positive as what they were getting in accordance with the Harper Trust decision isn't going to be easy. We move on to the other minor updates to the working time regulations. Like I said, in May 2023, the government also announced that consultation to make some further amendments to the working time regulations, but these are fairly minor. Some of them in relation to changes to how you record daily hours of work. There were also some changes going back to the COVID amendments we had, where employees could roll over holiday where they've been unable to take it during lockdowns. Now that is coming to an end as of March this year. And there's also some changes in relation to rolled up holiday. Again, something in practice, lots of the education clients and schools in particular, do roll up holiday pay. This technically wasn't lawful, but there was ways that employers were able to do that with minimal risk. Essentially, the amendments to the working time regulations now permit you to do it on the basis that you put in certain safeguards, including detailing on the pay slips what is in relation to the holiday. Just summarises those changes there on rolled up holiday. Lots going on in relation to holiday pay, but like I said at the beginning, lots of positive news. But again, if you have made those changes and looking at what you do going forward, do get in touch and we'd love to help you with that. Now, looking at trade unions and kind of what's on their radar at the moment, I guess the first thing to mention is the potential changes in relation to minimum service levels in the education sector, what impact in the education sector. So the government is currently consulting on changes to make sure that during strikes, there are minimal levels of service that continue to be applied to ensure educational needs of students are met. I would just say this doesn't apply to independent schools. It doesn't apply to the private sector, but it does apply more generally to the education sector. So the consultation is ending as of today. And if the new law comes into effect, there'll be changes in that regard in September this year. Something else that continues to be on the radar of trade unions is changes in relation to the TPS. As we all know, the changes are quite significant, coming into effect in April this year to increase employer contributions by up to 5%. We are certainly seeing interest from the unions as to employers in the independent school sector that are looking to change their TPS arrangements and potentially withdraw from the TPS. That said, I think it's fair to say that interest is unpredictable across the country, and certainly it seems that in some areas there may be a more conciliatory approach from the unions, accepting to some extent that change needs to happen. So we are speaking to lots of schools at the moment who are going through the process of withdrawing from the TPS or also considering other options around that. And if you're in that position, which many of you are, we do know that, it's worth just making sure that you are aware or potentially do expect there may be some potential strike action. In addition, it may be that this certainly galvanises potentially interest from the unions to get support for some kind of recognition. So I think it's just worth having that on your radar, and making sure when you are going through that consultation process, you make sure you take an approach which really tries to win the hearts and the minds of the staff involved. It's something we're helping schools with quite a lot at the moment, and if you need any support in that regard, please do get in touch and we'd love to help. In this slide as well, we've kind of set out other examples of campaigns where unions are showing interest. Common across all the unions are campaigns for real-term pay rises across the sector. So that's just something to be aware of. And I think that plays into your wider strategy in how you need to perhaps consider that and other options to ensure the financial stability of the school. And we're going to talk about that some more when we talk about other issues later in the webinar. That's all from me. Thank you so much for listening.
And I really wanted to just bring some thoughts and some horizon scanning around political matters. Now, the caveat at the start of this is to say that I'm not suggesting any political allegiance at all. I just think that it's really worth us thinking in this year of a potential general election of the sorts of things that might occur dependent on which party comes into power. So here we are. On the slide there, you will see that education remains, as I'm sure you will appreciate and understand, education remains a really crucial issue for voters. It is actually the 8th issue on the list of voter concerns for the 2024 election, according to YouGov. Now, whilst that doesn't mean it's right at the top, we've got some other significant issues in the country, of course, that are playing on people's minds, but education remains really up there as an area of concern for people. So I think, as you'll see, Labour are thinking about a number of changes and proposals within the education sector that are really going to be relevant for you to be starting to think about. Now, this depends on where you are in the sector. Of course, if you're in an independent school, you will be very alive to the fact that Labour have made it clear that one of their policy commitments would be to end VAT relief for independent schools. Now, that is something we are talking to our clients about, and indeed Robbie is going to talk to you about some of those issues as well later on in this webinar. A couple of the other points that Labour have mentioned there is that they would look at removing the minimum service levels in a strike that Charlotte just spoke to you about, that's only just coming into effect. So that's something that would go almost before it's arrived if Labour were to come to power. And they're also talking about potentially reinstating the qualified teacher status requirement as well. If the Conservatives remain in power, then it will be it seems as though at least it will be a continuation of the current agenda, albeit with some changes around curriculum for A-levels being replaced potentially with an advanced British standard, and also potentially the removal of performance-related pay for teachers. The Liberal Democrats, they're perhaps less likely to be successful in a general election, but equally they have some thoughts about education strategy there as well, and creation of a teacher workforce strategy to make sure that specialist education is in place for all pupils within secondary schools. I think the point with the Liberal Democrats, of course, is that even if they themselves aren't able to create a government on their own, if they were to go into coalition with one or other of the main parties, then they will be considering those different factors, and that might well play into any coalition that comes about. I think the other things that are particularly vital to bear in mind from a HR perspective, if Labour, for example, were to come into power, is that they have set out their first 100-day pledges for what they will bring about, and they have talked about bringing forward an employment rights bill. The big thing there, I think, there's a number of factors, but one of the big factors would be that they would look at bringing about a day one right for unfair dismissal protections, and protections for sick pay, holiday pay, parental leave, and other family protections from day one. Now, of course, particularly with unfair dismissal, we currently have a 2-year qualifying period. That would go under the proposals that Labour are putting forward, which has potentially an enormous impact. Also an enormous impact perhaps on the tribunal's ability, the tribunal service's ability to manage any claims that are coming through, given the challenges that there are for the tribunal service already. There is also the potential that they would ban 0 hours contracts for anyone working regular hours for 12 weeks or more. The proposal is that those individuals would be entitled to ask for a regular contract, for that to be put in place. And there is also the suggestion from Labour's policy plans that they would put in place a single status of worker rather than having this situation we have currently where we're looking at employees for some rights and workers for other rights. Labour have said that they would bring in one single status of worker, and then there would be the genuinely self-employed as a separate category. But those things in particular have the potential to be really quite significant. And also the other one that I just think is worth mentioning when we're thinking about employment tribunal claims is that Labour's employment bill is suggesting that they would strengthen workers' rights even further by extending the time limit for bringing employment tribunal claims from its current 3 months post an act of discrimination or a termination of employment through to 6 months, so extending the time that somebody would have to bring a tribunal claim. So as you can see, there's a number of issues that you will need to be grappling with depending on the colour of any government that might come into play later this year after a general election. So it's difficult to crystal ball gaze, but there are certain things there that I think are worth starting to think about and to see where you can plan and perhaps have discussions about it, any of which we'd be delighted to talk about if you'd like to do so. So that's all from the employment side of things. I'm going to hand over to colleagues.
Now we'll hear from our student issues team.
Welcome from the Birketts Student Issues and Disputes team. In our slot, we're trying to give you an insight into direction of travel in certain areas with which you may not be so familiar, but where we know you will see a change. We're going to start with a session from Natalie Kent on gender questioning children, especially in light of the current consultation. We're then moving on for Hanna Head to look at some stats around the increase in SEND tribunal claims. Naomi Westcott's going to cover changes in procurement legislation, which may affect your suppliers, and also look at the change of emphasis in procurement principles, which will affect you. And I'm Sara, and I'm going to conclude with some points on complaints handling. Each member of the team has been challenged to leave you with a top tip as they conclude their section.
Thank you, Sara. I'm going to be speaking about the government's consultation on the long-awaited guidance for schools and colleges in respect of gender questioning children. On 19th of December 2023, the government finally published their draft guidance for schools and colleges in respect of gender questioning children in the form of a consultation. The consultation closes on 12th of March 2024, and we can only hope that sometime following that, we will finally get some guidance in respect of this area. This is against the backdrop as the guidance acknowledges a significant increase in the number of children questioning the way they feel about being a boy or a girl, including their physical attributes of sex and the related way in which they fit into society. As you'll know, this guidance has been many years in the making and is following a number of leaked iterations of guidance addressing trans issues in schools. The guidance is, in its own words, intended to provide clarity for schools and colleges and reassurance for parents. The guidance is intended to give comfort to schools and seeks to address the lacuna which schools have found themselves in recent years in the absence of statutory guidance specific to schools and in the face of sporadic guidance which often conflicts with other existing statutory guidance and legislation. So looking at the guidance itself, the guidance cites 5 overarching principles. The first, that schools and colleges have statutory duties to safeguard and promote the welfare of all children. Second, schools and colleges should be respectful and tolerant places where bullying is never tolerated. Third, parents should not be excluded from decisions taken by a school or college relating to requests for a child to socially transition, and this is perhaps the most notable change in this guidance from previous iterations. Fourth, schools and colleges have specific legal duties that are framed by a child's biological sex. And fifth, there is no general or absolute duty to allow a child to socially transition. And looking at what the guidance itself actually covers. The guidance outlines steps that should be taken if a school or college wishes to accommodate any degree of social transition. It suggests allowing for a period of watchful waiting to see if a child sustains their desire to socially transition. This, in the guidance words, is intended to help ensure unnecessary action is not taken. The guidance covers the need for schools to make parents aware and consider their views as another initial step on which emphasis is placed. The guidance notes that only in very rare situations where informing parents might raise significant risk of harm to the child should parents not be informed. If, following the period of watchful waiting, the child maintains their position, the guidance lists further points that schools and colleges should take into account. For example, the age of the child. Schools should treat requests from younger children with greater caution, says the guidance. The guidance draws a distinction between primary and secondary school age children, a distinction which incidentally is arguably in conflict with the Equality Act. The impact on other pupils should be taken into account, and this point appearing to give a nod to recent case law, albeit in the employment sphere, which recognises the rights of freedom of thought and expression. And also the seriousness of the request. Schools and colleges are encouraged to consider whether any societal or other factors may have influenced the child in making their request. This includes the child's sexual orientation, as the CAS review, on which this guidance is largely based, found that sexual orientation can sometimes pressure children to reach a particular outcome regarding their identity. There is specific and at least in parts helpful guidance on pronouns, changing names, single-sex spaces, including toilets and boarding houses, uniform, PE and sport, and single-sex schools. Now, if you've seen any press or media coverage about this guidance, the chances are you'll have seen the widespread views and opinions that this guidance is in conflict with the Equality Act. This is largely because under the Equality Act, to be protected from gender reassignment discrimination, you do not need to have undergone any medical treatment or surgery to change your birth sex to your preferred gender, and you obtain protection from the point at which you are proposing to undergo a process to reassign your sex. Conversely, this draft guidance focuses on the factual reality that under the age of 18, a person is unable to obtain a gender recognition certificate and so cannot formally or legally change sex. Apparently, even the government's lawyers forewarned that this guidance was likely unlawful. So where does that leave us? At this stage, at least, this is only a consultation. You cannot rely on it. There is a school of thought that this draft guidance is testing the water and sets a high watermark from which the government will necessarily come down. Even following consultation, it is expected that this will be non-statutory guidance, meaning that schools may and likely will still be challenged by parents both for following it and for not following it. There is no model policy for schools to adopt within this guidance, as there is with other government guidance, and perhaps this is something that will come out of the consultation. This is guidance which will affect all schools, and it is really important that it reflects what the sector needs. And for that reason, we would encourage you to participate in the consultation if you have not already done so. But for now, at least, unfortunately, it is still a case of watching and waiting to see what comes of the consultation and what we will ultimately end up with.
Thanks, Natalie. I am going to give you all a quick overview of the current trends in the state sector on special education needs hearing claims. In recent years, there has been a notable increase in the number of parental complaints, and in particular, parental complaints relating to special education needs and disability discrimination. This has led to, in the academic year of 2022-23, SEND tribunals recording 13,658 appeals. This is an increase of 24% compared to the prior year. Appeals in the 2019-20 academic year were 7,917. In the academic year of 2022-23, 7,968 of the appeals were seen through to hearing, in contrast to 3,770 appeals in the academic year of 2019-20. Overall, the number of appeals being seen through to hearing is 3.5 times larger than in 2014-15 when the SEND reforms were introduced. In 2022-23, SENDist panels upheld the local authority original decision in only 139 of the 7,968 appeals that went to a full hearing. This is a local authority success rate of only 1.7%. Since the SEND reforms became law in 2014, SENDist panel hearings have upheld a total of only around 12% of local authority decisions. It is clear from the rising number of tribunal appeals and the overwhelmingly high rate of success for families how prevalent the disagreement is between parents and carers and the local authorities. Ultimately, the duty rests with the local authority to implement an EHCP, but they are under increasing budgetary and resource constraints. My takeaway from this: involve parents in discussions concerning reasonable adjustments so that you can get their buy-in.
Thanks, Hannah. Procurement is the process by which public bodies arrange for the delivery of public services to be delivered by external suppliers. There are many relevant considerations in procurement law that overlap with the requirements of charities, especially the need to be clear, open, and transparent with your procedures and to obtain value for money, which is also a goal of non-charitable schools. It is therefore useful for schools to understand elements of public procurement law, which is currently in a state of flux with important changes on the horizon. Under the current procurement legal regime, Regulation 18 of the Public Contracts Regulations, the principles of procurement are established as non-discrimination, equal treatment, transparency, and proportionality. However, the current regime is being replaced by the Procurement Act 2023, which has royal assent and is anticipated to come into force in October 2024. Under the new Act, the procurement objectives will replace the Regulation 18 principles. Now, those objectives are delivering value for money, maximising public benefit, sharing information for the purposes of allowing suppliers and others to understand decisions, acting and being seen to act with integrity, treating suppliers the same unless a difference between suppliers justifies different treatment, and having regard to the fact that small and medium enterprises may face particular barriers to participation, after which they should consider whether such barriers should be removed or reduced. There is therefore a marked shift away from the most economically advantageous tender evaluation to instead the most advantageous tender, This is reflective of the shift towards considering other issues on the government's agenda, such as social value, sustainability, and environmental considerations, which are all issues that we are increasingly seeing being considered within the independent school sector. So, my top tip would be ensure you consider all the factors, such as social value, not just the monetary value. Thank you.
Thank you, Naomi. So I've been practicing in student issues for over 20 years and have seen a significant increase in complaints, especially since COVID, and especially in stage 3 panel hearings. So you are not alone in this. From the huge number of cases we handle, we can actually identify some themes, and we want to share the benefit of our experience to help you in how you handle your complaints. Firstly, it might be a basic, but actually follow your policies and principles. They're an internal mechanism that allow you to put things right that may have gone wrong. They're an opportunity to put your house in order. Also, you need to take your complaints seriously. And by this, what we mean is be objective, see it less as a personal attack, but more as client feedback. Parents are consumers, they're buying education from you. So in terms of how you handle the complaints, what we see as successful is when your communications are positive and when you're constructive in your ideas and suggestions and your language. You're striving for a de-escalation. You're trying to sort things out early to bring early resolution to problems. As an insight, we're actually seeing an increase in the number of complaints around the handling of safeguarding matters by how the senior management have handled the safeguarding issues, not being directly involved, but how they've overseen issues and how they've managed it. And we've actually seen an increase in the number of referrals to the TRA around how senior management have handled safeguarding issues, and actually the TRA becoming more interested in how senior management is responding on complaints handling and on safeguarding issues. So my top tip for sharing with you is around communication. Put yourself in the recipient's shoes. How do you look? What's your tone? How are you coming across? What's your content? What are you saying? Because also you need to bear in mind that the chances are the parents are going to stay in the school. So you likely are going to have an ongoing relationship with them, and you need to bear this in mind. So hopefully this experience, the experiences we've shared today, have helped you and your thinking and your approaches on the issues we've covered. Thanks for your time.
And now we'll be joined by Robbie Watson in our tax and trust team.
One of the major talking points in the education sector concerns Labour's proposals to remove the VAT exemption and business rate relief for private schools. Private schools currently benefit from a VAT exemption for fees for education and any closely related goods or services. Labour's proposals would remove this and subject the fees to 20% VAT. It is currently unclear, in the absence of legislation, whether the change would apply to everything covered by the current VAT exemption, i.e., would it apply to closely related goods or services, such as accommodation, catering, transport and school trips? If school fees become chargeable to VAT, while schools would have to charge 20% VAT on their fees, the financial impact on the schools is unlikely to be the full 20% increase. Schools will seek to recover VAT incurred on expenditure relating to fees, which was previously irrecoverable, and any other taxable supplies they make. There is also a possibility that some elements of the school fees, such as welfare services and transport services, might be exempt from VAT. Any exempt services and VAT recovered by private schools will reduce the financial impact of the removal of the exemption. Accordingly, schools may decide that they will not pass on the full 20% VAT increase. Schools may also have income from other sources and investments that could be utilised to prevent this. There is a large variation in the type of private schools that will be impacted by this change, from large well-known public schools to smaller and less financially secure schools. These changes are likely to have a much larger impact on smaller schools, as they will have fewer resources and support, and they might struggle to survive. Such schools are likely to include foreign language schools, faith schools, schools with alternative teaching philosophies, and schools for children with special needs. It is possible that Labour, as it has in the past, could promote the transitioning of such schools to state schools. While the Institute for Fiscal Studies have stated that the proposal is likely to raise £1.5 billion, which is a small amount in the context of an overall £1 trillion budget, there could also be negative financial implications, given that the change is likely to price some families out of the private sector altogether. The Independent Schools Council suggests that 20% of parents could withdraw their children from private schools. The consequential movement of pupils into the state sector, in addition to the increased recovery of input VAT, could reduce the amount raised by the measures, with some commentators suggesting that the movement of students could cost the government more than £400 million over the course of 5 years. Labour plans to introduce the changes immediately after election, which would give schools very little time to prepare for the financial impact or to increase their fees. The desire to introduce the change as soon as possible is likely to be hampered by a combination of the complexities of amending the legislation, holding a consultation process, the need for parliamentary scrutiny, a bottleneck of parliamentary time, and the call for taxpayers to be given time to prepare for the change. It is therefore unlikely that any change will be introduced immediately, and we have even seen some commentators suggesting that the changes will not be introduced until the year 2026. A number of advisors have proposed solutions for parents to overcome the financial impact of the change, the main proposal being the advance payment of school fees before any proposed change. When VAT becomes chargeable depends on the tax point of the supply in question. It is therefore theoretically possible that advance fee payments could trigger the tax point and accordingly benefit from the VAT exemption before any change. However, Labour have indicated that any such changes are likely to include anti-postallion measures, which could invalidate such prepayment schemes. The general rule regarding the introduction of anti-avoidance measures, such as these, is that the legislation will be retrospective with effect from the date on which the measure was announced. However, as HMRC is likely to regard such advance payments as abusive, they may fall within the wholly exceptional circumstances where changes to tax legislation can be made with a date earlier than the date of announcement. As there is no detail of the proposed legislation, it is unclear whether such advance payments will be invalidated, but it would seem that this is the current intention of the Labour Party. Other risks of paying advance fees are the potential insolvency of the school and losing the advantage of the use of this money over time. It therefore seems sensible for parents to consider the economic viability of the school and how it will be impacted by the changes, whether the school intends to pass on the entire 20% VAT charge for increased fees, and whether the school will be able to recover additional sums in respect of VAT in the future. There is clearly a cash flow advantage for schools in taking advance fees. However, schools will also want to consider their fee arrangements to ensure that provision for any retrospective assessment for VAT is already factored into their fees or can be recuperated from parents. Schools should ensure they are prepared for any change by reviewing and amending their accounting systems to ensure they are able to maximise VAT recovery. Schools may also want to consider how they can restructure their current activities to maximise income and recovery by fully exploiting their premises and facilities, making more of their supplies to students chargeable, and incurring more recoverable expenditure in relation to these supplies. Whatever changes lie ahead, it is advisable for both parents and schools to consider their particular situation and to start advanced planning in order to manage the impact of any change. Private schools currently also benefit from business rates relief at a rate of 80%. Labour's proposals also include the removal of this exemption from buildings occupied by private schools, mirroring that removal that has already occurred in Scotland. Although private schools will already have their buildings valued for business rate purposes, given the 80% increase in rates, it may be sensible for private schools to revisit the valuations of their buildings. Traditionally, private schools have been using the contractor's basis, which assesses all the costs of providing modern equivalents, instead of applying comparable rental evidence. We understand that the Valuation Office agency is now increasingly applying rental evidence instead, which is likely to increase the rateable values for schools. This area remains uncertain, but we note that schools may have grounds for appeal where they disagree with the valuation method used. There are also opportunities for private schools to obtain a reduction in rates where they have buildings that are undergoing or have undergone refurbishment or are taken out of use. However, given the complexity and uncertainty surrounding this area, we would suggest that private schools speak to valuation experts on these matters, as it may be that a more favourable valuation can be obtained. Thank you for your time.
And now we'll go to Amanda Timcke in our commercial property team.
The education sector is dealing with the ever-present drive to enhance and improve curriculum and facilities to attract parents and retain pupils into their educational establishment, ensuring best value in a competitive environment. In doing so, they often need to look at the management of their estates, and in particular, investment, raising capital for core operational, trading and improved facilities, and protecting their assets, as well as looking ever more at decarbonisation. Having a rolling programme, both proactive and reactive, can ensure they safeguard their estate from the adverse effects of climate change. But all of this takes place in the backdrop of difficult and challenging times with a number of risks. There are inflationary pressures, budgetary constraints, and falling income, as well as the conflicting position of operational and educational side of the business. What we would recommend is that at a basic level, you ensure you've got a surveyor and solicitor instructed who are very much immersed in the market and sector and aware of your assets by way of inventory and deal with valuations to see whether or not there are opportunities available to you, such as debt funding or property company, operational company arrangements being put in place, often by way of sale and leaseback of assets, or otherwise to identify surplus assets which could be disposed of. By doing this, you can also identify opportunities to collaborate with other educational providers in your communities and consider joint ventures or even shared service opportunities. What is important to know in the backdrop of this sector is ownership arrangements whereby entities who beneficially own the legal entities which run the independent schools are often slightly unusual. They can be domestic or overseas entities, charitable trust, companies, or even private individuals. They may have different objectives and must be borne in mind when assessing estate management. One must also remember that the government has an agenda on making things transparent around ownership. The Levelling Up and Regeneration Act has brought in a consultation now on how they will disclose more information about land ownership by trusts. At present, the Land Registry holds a record of property, proprietorship and charges on land, but does not disclose beneficial ownership in detail. The proposal is that 3 new registers will be created, making public information regarding beneficial ownership of land, who exercises control over land, such as collaboration, joint ventures, overage agreements, and who owns land that is deemed to be of importance to national security. The aim is to expand information on trusts, which is currently available, particularly around controlling overseas entities. When the Economic Crime Transparency and Enforcement Act 2022 was created, it became fairly quickly established that the government was looking to record ownership and all entities that own land, especially when hidden by a trust. This was all centred around prevention of crime, but it seems that the government wished to go further, requiring fuller disclosure of all trusts and who they own land for. The consultation on how this is enacted is in place until the 21st of February, and I encourage you to raise this with your board and consider whether any representations could be made. Thank you. That is Education Property.
And now we'll go to Emma Chiaramello in our construction team.
Hello, my name's Emma Chiaramello. I'm from the construction and engineering team at Birketts, and I'm going to be talking to you about the Building Safety Act. Now, this act has been in preparation for some time. It was born out of the Grenfell tragedy in 2017. It introduces a whole new regulated regime in construction, and it's being brought into force incrementally. Now, a lot of people consider that it only applies to high-rise buildings, but that's not the case. It applies to all buildings, and therefore it's relevant to all building owners, which is why we're including it today. So what does the Building Safety Act entail for all buildings? Well, there's now a building safety regulator, which is part of the Health and Safety Executive. And that is the regulator who's responsible for the performance and safety of all buildings, and they also supervise other building control bodies. There's a new statutory duty for duty holders to take all reasonable steps to reduce the risk of fire spread or structural failure. And that role applies to all of those who procure, plan, design, manage or build any building or arrange works to any building. And that's not just high-risk buildings. There's now a focus on organisational and individual competency as well. We have a new competency framework which applies to all trades involved and the professions. This is modelled on the CDM regulations, which is relevant to health and safety law. There is a legal duty on any clients such as independent schools who may be organising works to any buildings, and that legal duty is for them to consider occupational and organisational competency when appointing or organising works to any buildings. It's also necessary to consider yourselves as duty holders, and it's part of your responsibility then to take those steps to reduce the risk of fire spread or structural failure. So it's not just roles like that under the Building Safety Act. There's also a specific new regime for higher risk buildings. And what are higher risk buildings? Well, they're the ones that are over 18 metres or 7 stories, and provided there's more than one residential unit in them. And effectively, the Building Safety Regulator is building control for those buildings. It's no longer possible to use a private company to act as building control. Now, the regime for existing high-risk buildings is that they should have been registered on the HSE portal by the end of September of last year. And that really is the first step for any residents of those buildings to show that they are safe to occupy. There should now be a risk management strategy and plan by the accountable person who's responsible for those occupied high-risk buildings. High-risk buildings also require a golden thread of information, and that golden thread of information collates together all design, construction and occupation information in respect of that building, and that is a responsibility of the accountable person and the developer. That needs to be stored digitally as well. And really the focus is to review that information, keep it up to date and identify any gaps in that information, getting third-party help if you need it. Now, it's important to recognise that the regulator has started its review of all the existing high-risk buildings and reviewing the risk assessments as well. And this is another step that brings greater confidence for resident stakeholders of high-risk buildings. In October of last year, there was also a registration opened for new build high-risk buildings, and there's now 3 gateways or decision points, checkpoints if you like, in the construction of new high-risk buildings, and that is in the planning phase, the pre-construction phase and the pre-occupation phase. So it's not just about the new regime, there's also enforcement to consider. So now the regulator really is tasked with this, and there's a big focus on training and competence, but it's a situation where they're encouraging compliance with carrots and sticks, because there are also several corporate and individual offences that could lead to unlimited fines and 2 years imprisonment if you do not comply with your duties under the Act. For example, if you allow occupation of an unregistered high-risk building. There's also increased possibilities of civil claims in that building owners, landlords and developers are being required to pay for the remediation of historical safety defects. There's also new extended 15 and 30-year liability periods relevant to historical safety defects in dwellings under the Defective Premises Act. We're anticipating further updates in April 2024, and what we're looking at for the future. there is in future likelihood of being able to bring civil claims under the Building Act for breaches of building regulations once Section 38 of the Building Act 1984 is brought into force. And there's likely going to be requirements, amongst other things, for 15-year new home warranties. So what can we do now? The key thing really is to assess any buildings, any assets or projects that you've got going on. Whilst the golden thread of information is relevant to high-risk buildings, I would suggest it's a good idea to ensure that you have got a collated set of information relevant to your buildings available digitally, and that you review that paperwork and ensure there's no gaps in it. If you have gaps in your knowledge about your buildings, then you need to try to fill those gaps, and that is the prudent thing to do. And you can get third-party help with that if necessary, and really be aware that the regulator is going to be reviewing these, particularly with high-risk buildings, and prioritising the highest risk buildings first. The key takeaway point is that it's necessary to show the building safety regulator you're aware of your duties, primarily the one of duty holder, and that you're taking steps to comply with the Act. Now, to conclude, I just mentioned that this is a very, very big topic to chat to you about within a short space of time. So I would encourage you to stay briefed on it, to sign up for our construction webinars via the Birketts website, and also to review the HSE website if you wish to know more about the Building Safety Act and your duties under it. Thank you.
Well, thank you very much for staying with us. We hope that you really enjoyed our webinar today. And as mentioned, it is the first in a series of webinars and other matters and podcasts that we're running this year. So please do subscribe. If you have any thoughts, we'd love to hear from you. We will be sending out a feedback form, so please do let us have your comments, particularly on things that you'd like us to address in future webinars or podcasts. And as mentioned, you can also contact us directly. All of our contact details will be following and also available on our website. So please do get in touch. And if you have any questions, we'd be happy to hear from you.